Okay. Welcome back to this EPP public hearing. I understand that coffees usually allow people to talk a bit more, but may I please call everyone to start the second panel. On the second panel, we will be discussing the Commission's proposals related to value gap, and that is why our guest speakers on this panel will focus and represent the different stakeholders in audiovisual, and will also focus and also represent different stakeholders in this value chain. We are running slightly late, so you will hear my voice even less than in the first panel. And I will give the first word to Adam Kinsley, who is Director of Policy at Sky. And we will start with that first address. Thank you.
Thank you very much, and thanks very much for the opportunity to speak on this important panel. As many of you know, Sky is Europe's leading pay TV company with over 22 million customers. We operate a portfolio of content brands in 5 EU member states, and we have an annual content budget of over 5 billion euros. And this supports 130,000 jobs across Europe, contributing 9 billion euros to European GDP and 3.5 billion in tax revenues. Our content investment combines acquired content with an increasing original programming budget, and we've currently got over 250 series in development or production. And our content is distributed widely over satellite, cable, DTT and OTT. You probably know all that. What you may be less aware of is that Sky is also a telecoms company in the UK. We're the second largest telecoms company, operating with over 5 million customers. We offer broadband, telephony, Wi-Fi, and now mobile as well. So we are a converged player, very much a converged player, and we observe with great interest the tension that you see between some of the protections over intellectual property with the safe harbours and the exclusions that are found in the e-commerce directive. We observe it with interest, and we think that we have a unique perspective on this. We do understand that internet providers need certain protections, but it's clear to us that the world is very different today than when those protections were originally agreed. Technology and its uses have changed in ways that no one could possibly have predicted. So before I get on to some of the specificities in the proposals in the Copyright Directive, I want to spend just a little time explaining the challenges that we face in protecting our significant investment in European content. And the challenges are very real. And if we fail to be successful in protecting our investments, it's not controversial to say that future investments will be much, much harder to justify. And less investment means clearly fewer jobs, less content and reduced cultural diversity. So it really does matter. So I mentioned we make our content available on a range of platforms, but it's also made available by others without our consent, without payment, illicitly, and that happens systematically. The people that do this use our content to profit from their activity. It's a serious erosion of intellectual property rights, and it undermines our investment. And it's using technology that was not countenanced in earlier directives. So, for example, where historically illegal streams of a movie or a sports match may have appeared on an isolated website, today they're aggregated on apps. And they're made available on the Apple App Store and on Google Play. For download on mobile phones and on tablets. So that's a huge challenge to our apps like Sky Go, which our customers have paid for. So we will deal with those threats by informing the app stores that they are listing apps that have unauthorised content. And whilst the app stores may contact the app developer, what typically happens is the app developer just says, well, we're not breaching copyright, and it seems to be that that's the end of the story. and that just can't be right. And I'll give you just a couple more examples of technologies that have emerged from the information society in recent years that we think the legislation may not have anticipated. So platforms like Twitter and Facebook offer fantastic experiences allowing users the ability to share live streams through applications like Periscope and Facebook Live. But you can imagine that this also creates opportunities for digital piracy. So for us, that's a huge challenge, but at least we can regularly update our processes and update the technology that we use to try to deal with these threats. But I can see that it creates a much bigger challenge for legislators who only get the chance to update the law periodically. And that's why opportunities such as this are so important, because they don't come around very often. And then I'll give you just one more example of technology that has changed for us that creates very significant problems. Plug-and-play boxes that will go straight into your television, about that big, could be a box, could be a stick, turns your television into a connected internet-connected media hub. And the problem is that these sticks are often loaded with software that can scrape the internet for unauthorized content and then aggregate it. And worse still, these digital TV pirates create their own pay TV offerings using our content, either live or video on demand. And whilst this technology may be so new that it's not countenanced in any legislation, a new generation of users are growing up and that they are using this. And some of the statistics are quite staggering. So 14% of UK internet users have found to be infringing using these boxes, and that figure rises to almost 50% for 16 and 17-year-olds. And the boxes are listed on online platforms that you will know, like eBay and Amazon, and that gives them a legitimacy. And in a recent study, 44% of people said that they agreed that they assumed that if they bought a stick or a box from a retailer like Amazon, it must be legal. So whilst there is unauthorized music uploaded to YouTube and the value gap proposals deal with those, I want you to be aware that we shouldn't focus all of our attention on this one problem. In fact, we're very disappointed that the directive does this. We have a few questions about this. We'd like to know why Article 13 is so narrowly defined, why it isn't technologically neutral, why it only refers to information society providers who store and provide public matter that is uploaded. What about when it's not stored? What about when it's streamed? We need to look at this very carefully at the narrowness of each aspect of Article 13. And even speaking as an internet service provider, I say that the safe harbours and liability exclusions that exist are far too wide and are out of date, and we should use the debate around the copyright directive to clarify where they're truly needed and where some players could take responsibility to help protect copyright and support Europe's creative industries. And we should look at some of the recitals to achieve this. I think we need to use the time over the coming weeks and months to really examine what else can be done to protect the creators. To be clear, this isn't about trying to extend Article 13 proposals to small or emerging players. It's about looking at the other large-scale providers and asking what more can be done to ensure that information society providers support rather than detract from Europe's creative industries. What more can be done to make Article 13 more technologically neutral and fit for the future? And in the longer term, I'd urge the European Commission to think really creatively about better IP enforcement, including better legislation to support copyright enforcement. So I hope my contribution as a converged content provider is helpful, and I look forward to the debate later. Thank you.
Thank you, Mr. Kinsley. I now pass the word to Burak Özgen, who is Senior Legal Advisor of JESAC.
Thanks very much for this invitation and your interest in JESAC views. JESAC is the European group of societies of authors and composers, and it represents more than 1 million creators through its 33 members across EU and EEA. And their main job is negotiating and licensing collectively the rights of the authors that they represent. But the situation faced by the creators today, and this one is not working. All right. Okay. The situation faced by the authors today is the biggest usage of their works on the internet says that they are not bound by the copyright rules, and then they are covered by the safe harbor regime just because they operate their service based on the content uploaded by the users. So this means that the only legal option remains to the authors is trying non-stop day and night taking down the content, which is mainly and mostly inefficient, very costly, and not very much desired by the authors anyway. Or they need to accept the take it or leave it deals offered by some of the players in the market. And in those deals of the take it or leave it, they are even not able to actually enforce and ask for the accurate and relevant information from those services, and they usually get very messy and unsatisfactory data. And it's a concern not only for authors and not only for music sector, as you see shared by the entire creative sector. So this actually creates, as a result, a legal loophole that enables the biggest global player to free ride. As a result of that, an economic problem endangering one of Europe's best performing sectors, cultural and creative industries, which has been recently stressed by the EP report as well. And it's a political issue too, because it threatens the EU's fundamental values such as rule of law, non-discrimination, level playing field, cultural diversity, because those players do not comply with the EU's copyright laws, as actually they are also seems to be doing the same thing in the other areas of the EU law, like privacy, data protection, competition, tax, and everything, in order to maximize their own profits. So this is a huge and even growing problem, because indeed they are the biggest users of our works. You look at the economic studies coming out every day nowadays, they are generating more consumer traffic than all the other licensed services combined. When you look at the services, the most popular content is the creative content. When you ask the consumers which services they know and use, they're at the top. And most of them refuse licensing, as I said, or some of them offer peanuts. And when we try to challenge them in the courts, the current EU law that should apply to them has not been clear to the national judges. Across Europe, in Germany, in Italy, in Spain, in France, in Poland, in the UK, courts look at the very similar cases and give completely contradicting decisions on the same issue and the application of the same law. So our hands are tied, and then you cannot really risk very long, lengthy, and costly legal proceedings for a case whose result is not sure. And this actually distorts the competition in the market, affects actually startups that are trying to enter the market because they need to compete with the free players, free riders, and actually affects the choice of the creators because they cannot set the real value of the content in the digital single market. So that's why we've been asking, on behalf of the creators we represent over the years, two things. First, clarifying that such self-proclaimed internet intermediaries undertake copyright relevant tax, and then when they do so, they cannot claim safe harbor regime. So that will lead to fixing this legal loophole by a clarification in the law only. So why there is a communication to the public undertaken by user-uploaded content services? Because first of all, Article 3 of the InfoSoc Directive and the WIPO Internet Treaties say there is a communication to the public where the members of the public may access the works from a place and at a time individually chosen by them. That's why the Court of Justice said in Swenson and Telecable rulings, accessibility of the content is enough to establish the communication to the public. It referred in every case regarding communication to the public to the indispensable role played by the user in making the works available to the members of the public. And actually it also referred to the possibility of having one act with two parties involved in it. So as long as the role played by the parties is indispensable and then going beyond the mere provision of physical facilities. This is exactly the case with the services that we are talking about, and then they are actually making all the convenience and act as a digital service provider for the consumers by making those works available. So then you need to look at the situation whether they are actually liable for this act under the e-commerce directive, whether they have an active role or a passive role. And in that thing, you need to look how to reconcile e-commerce directive and the communication to the public. In order to have this optimization of the presentation or promotion of the content, so to give control over or the knowledge of the content, you need to look at these elements. So does it really require command on every single works that will be uploaded by the user? Of course not. The current available technologies to control the exploitation of the work is enough to establish that. And do you really need the knowledge of every single content that will be uploaded by the user? Of course not, because copyright liability never requires editorial responsibility. You are liable for the copyright when you have the full knowledge of the consequences of your act, which is a provision of the content to the public. So this means actually, this clarification means actually not changing the e-commerce directive or not changing the infrastructure directive. But it will certainly change how those players are treating the authors right now, and this is exactly the aim of this legislative intervention. And another important element of the law is the need for cooperation on technical tools. This is absolutely an essential element for any type of licensing taking place in the market, because without the knowledge, without the data, you cannot manage the rights. This is the key for us. And we all need to understand very well that we are always there to license the works, and in the licensed environment, all content on the platform will be legally available with legal certainty. So this means actually the uploaders, the consumers, will not be bothered or think about whether they need to clear any rights, whether that content will be blocked, whether that content is subject to an exception, because the platform licensed the works, and that license covers the act of the consumer as well for the communication to the public. So this is a very simple process, and it can be done easily, and then it actually gives away most of the burden from the consumer side too. And another element is the cooperation between the parties. This is really, really key, because cooperation requires involvement of both parties. Currently what happens is those services do not cooperate at all with the right holders. Some of the right holders who are trying to block their contents, maybe sometimes very aggressively, fighting with each other, that leads to some actually unjustified takedowns that are complained by the consumers. And then when we speak to the digital rights organizations, they say those services usually take down more content than they are supposed to do based on their user terms of services, and in order to remain on the safe side. Well, as long as parties are ready and willing to cooperate, these problems will be minimized, if not eliminated, and the machines can learn in time if actually the service is willing to do that. And in the end, the obligation to cooperate is only when you play an active role, which you need to do anyway, or if you're a dominant player in the market, and only for the content that is informed by the right holders. So it does not go beyond any actually necessary requirement. This is a good step from the European Commission, but it needs to be completed, and the law should aim for creators at the first place. If a service is a content service, it should be treated as one. Secondly, cooperation is key to make sure that we can actually receive the relevant and the accurate data from those services. And actually the impunity of these free riders hugely benefiting from the content is ending after this legislation. And for consumers, it's very important. It should focus on licensing the platforms so the acts of the users will be covered too. It should focus on having more content available legally on the platform, which would lead to less and more accurate takedowns where necessary, and better services and redress mechanism for consumers, because where the services do not deliver well for the consumers, it's not an excuse to weaken the rights of the creators, but it's only a reason to develop better rules for consumers vis-à-vis such services. This first positive step taken by the Commission is not only the result of the huge mobilization of the creators across Europe, but also actually the efforts of the European Parliament that mentioned in several occasions, first in the so-called Redress report, and then in the CCI report prepared by MEPs Eller and Morgano, and in a separate letter signed by a number of MEPs asking to stop this transfer of value. We are now, as a creative sector, asking the Commission to show a strong commitment and to address this issue in a good law to end this transfer of value. Thank you very much.
Thank you, Mr. Özgen. And I will now pass to Patrick Ater, who is the Secretary General of 5 different organizations. Because that's what's written on my paper.
Thank you very much, Mrs. Comodini, and thank you very much to the EPP for having the opportunity to sit on this panel. I'm the Secretary General of EXA, the European Composer and Songwriter Alliance, yet I'm working together with 4 other associations of authors which joined an informal alliance 2 years ago called the Authors Group, representing more than 500,000 creators. Our members are the composers, are the songwriters at the origin of the music value chain. Our members we represent other journalists, the investigative journalists, the newspaper journalists, writing in the press sector. Our members are also the writers and the literary translators, and of course the film directors and the TV directors working in the audiovisual sector, as well as the screenwriters. Why these 5 groups came together were that we felt that in the ongoing discussions of the copyright reform, the issue of fair remuneration for authors must be stressed and emphasized. It seemed to us, and it still seems to us to a certain extent, that whilst everybody agrees on the general principle of fair remuneration, it is far more difficult to establish in practice. It is a complicated mechanism. There are various stakeholders involved. There are obviously between the author and the consumer, the publisher, the producer, the collecting societies, the DSPs, the ISPs. So there are many different stakeholders, and all have a responsibility and an interest also in that remuneration. So to find a system that the value which is originated through the exploitation of the work, that this value ends up at the very source of the value chain, is kind of what we are looking at. And to make it even more complex, the different remuneration schemes in the different sectors which we represent together, namely the music, the audiovisual, the literature, and the journalism sector, are completely different. The role of the societies, the collecting societies, are different in each sector. The role of the publishers or the producers are different. So it's fairly complex. But there's one element, and I think it's not rocket science to understand that, but there's one element we discovered which has a determinative effect on the remuneration of the people we represent, namely the contractual situation. Basically, the contractual terms setting out the assignment or the transfer of rights from authors to publishers or to producers. And those terms are fairly similar, irrespectively of the sectors. In most cases, the copyright contracts which we have seen in the last years, and believe us, we have seen a lot of copyright contracts contain an assignment of rights or transfer of rights for the entire duration of copyright. And that is, as you know, all lawyers in the room know that pretty well, is for a very long time. And the rights assignment is also for all present exploitation or economic rights for the entire universe and future universes. So there's a very broad, basically a very, very total assignment and transfer of rights, whether in the audiovisual or in the literature or in the journalism sector. This is not always working very well. We looked into just the last 2-3 months if there had been any news on some disputes between some of our members or affiliated members with their publishers or the producers, and there's constantly something where the author, who is the originator of the value chain, believes not to be fairly rewarded on how he or she works had been exploited. And those who we snippled here are just very, very top writers who have probably the means to take legal advice and to address the situation in court. That's why, giving this context, for us the value gap is not only the value gap between the online platforms and service providers such as YouTube or others, and obviously we think that the provisions in the directive in terms of making sure that value from the online service providers reaches the original creators are welcome by us, is a very important element, but they must be complemented with mechanisms to ensure that the value gap between the author and the publisher, or the author and the producer, depending on the sector, is also reduced, and that there's more certainty. So that's why we welcome the Articles 14, 15 and 16 in the draft directive, which look into the contractual remuneration. And I would like to very briefly go into this. We just very simple believe that it is a sort of a transparency triangle, that setting an obligation to everyone who has obtained via an assignment or transfer rights from an author, setting an obligation for transparency to disclose information to the author, will enable the author then subsequently, on the basis of this new transparency obligation, to eventually readjust the contract and to use a dispute resolution mechanism to facilitate possible disputes. So that's a very nice, very good new narrative, and we would like to applaud the European Commission for doing so. The problem is that whilst it is it looks very good, in practice it won't change a lot, and we need to complement these provisions in Article 14, 15 and 16 with a few elements that we believe are still reasonable, but when implemented in national law could become a new reference. So we have some suggestions. Obviously, we will not miss the opportunity to state them here. With regards to Article 14, which provides a reporting obligation, we believe that it is very essential that for publishers in the music and also in the literature sector, that there's also an obligation to disclose the promotional activities. That's the very essence of a publishing contract, and the information we receive from our members is that after 2-3 years they don't hear back from their publishers. There are no emails which are responded. So what is done to promote the actual work? For the audiovisual sector, a very important element is also to find a mechanism that subsequent transferees, when, for instance, an audiovisual producer further license or sells the rights to a broadcaster, that the broadcaster also discloses information. So we would have some drafting suggestion on this as well. With regards to the contract adjustment mechanism in Article 15, setting out a mechanism for authors to claim additional remuneration in case of disproportionality between the original remuneration and the benefits derived out of the remuneration of the work. Here we need also to add a rights reversion mechanism. There are several member states who have some sort of rights reversion mechanisms. Those should be sector-specific, but as a general principle, if a rights assignment or a transfer of rights is for 70 years after the death of the author, it seems to us just to be duly justified that in case of non-exploitation, in case of non-promotion, in case of non-transparency, that the author can reclaim back their rights. The United States Copyright Act, which is a very market-driven act, has those mechanisms. And also for the audiovisual authors, an entitlement to equitable remuneration and proportionate remuneration would be essential. Finally, for the dispute resolution mechanism, here it's very important for us that we can also have collective representation or association representing our members in those disputes. There's a fear of blacklisting, there's a fear of exposure, so that would be a very positive element if we could add that. And I think if this is done well, the text with the proposal on the liability of platform, if this is entered into force with this transparency mechanism, could really change the system in the EU. And I would like to conclude with this, that our members are really those who work in the internal market in terms of cross-border services. We have a lot of members who live in Germany, who write for companies in Holland. So they need to know that there's more or less the same contractual provisions in the different member states. And it would be only fair, in our point of view, that there's a level playing field for all authors. Why should have authors in Austria or in Spain less good contractual provisions in copyright law than those in Germany and Holland, which have already very established? So the closing point for us is also the consumers will have more certainty that their value reaches the creator when they use online services. So this all also for the benefit of society. Thank you very much for your attention.
Thank you for those proposals. And I now pass the floor to Tobias McKenney, who is a Senior Advisor on Intellectual Property at YouTube. And we need a clicker, please.
Oh, sorry.
Thank you, Mrs. Rapporteur, for the opportunity to speak before such a distinguished audience. I will hit the ground running quite fast. Presentation. It's a very dense topic, and I'm sure many things will be said. I want to be very concrete in this presentation, and I will go over first what YouTube is, just to set the ground from the beginning, and I want to talk about then how Google fights piracy, how YouTube fights piracy, how YouTube creates value for creators, and then I want to finish and conclude on the challenges we have experienced in implementing use of technologies that might be called content recognition technology, and that we believe that might be relevant to the discussion that this House will be having on Article 13 and the directive. So first, roughly speaking, to introduce YouTube. YouTube is a video sharing platform. It is a platform where consumers from all over the world upload videos at the rate of 400 hours per minute. Most importantly, it is an open platform, and that means that anybody, any consumer, can upload and share a video on the platform. And that does mean that we see great creativity and great diversity in terms of the videos that are uploaded to YouTube. Obviously, it's not just about music, and it's impossible to categorize exactly what goes on in the platform because it's so diverse. So one attempt here is to categorize the different communities, business communities, social communities, or indeed creative communities that use the platform. Here you can see another example, which is the success of educational videos in the EU in 2015 as an example. So from that slide you can see at least two things. One is in that sub-segment there's quite already a diversity of different subsets of videos, and there's also a huge popularity for some of this content, such as science videos, who attracted 1 billion views in the EU in 2015. So again, to bring some evidence and some data points to what happens on YouTube, the platform is so diverse and open in terms of what type of creativity happens there that in reality consumers listen to a relatively small amount of music, 1 hour a month on average on a service like YouTube. Now, to put things into perspective, on a digital music subscription service you'd be looking at 20 to 50 hours a month listening time. So it's a totally different order of magnitude. Having briefly introduced YouTube, I want to move on to the next points, and this is about how, on the one hand, YouTube has innovated to fight piracy and to transform this also into an opportunity to generate business opportunities for right holders and for the creative community. And if you will, the challenge here is how do you maintain the value of an open platform where any consumer can upload a video, while at the same time giving right holders that control and that sense of empowerment that they can exercise some control when some of their copyrighted material is being reused on a video sharing platform. And one of the ways we have addressed this principally actually is through the use of something that we refer to as Content ID. So I want to very roughly outline what Content ID does. And I don't want to go too much into the weeds, but this is important for the rest of the conversation, I think. First and foremost, this only works if right holders provide us with files and information about what they own, to be very clear, and then tell us what they want Content ID to do. That being said, if you move to the left, you see this represents the consumer uploads or fan uploads to YouTube, these 400 hours. So you can think of a video of your child's birthday with some music in the background, or you can think of a science teacher uploading a video about space with footage from the European Space Agency. That video is uploaded by a consumer. It gets scanned by Content ID. If Content ID detects what we call a match with the corpus or the library of references provided by right holders, then Content ID will kick in and will apply the rules, the predefined rules that right holders have given to us and to Content ID to apply. So these basically means that the right holder can block the video won't appear on YouTube. They can leave it up and track it, collect data on the audience for the video. And the third option is for the right holder to tell YouTube to leave the video up, place ads on the video, and generate revenue for the right holder. So you can tell from the previous slide that at a very basic level, you can see Content ID as an enforcement mechanism or as a tool for right holders to control their copyright and make sure they block videos that include some of their copyright materials from appearing on YouTube. And yes, Content ID is very effective in working at scale. It's more effective than individual requests to remove specific videos on copyright grounds. I think the figures here tell us that the tool is extremely popular with right holders as a copyright management tool, in particular in the music industry. So sound recordings, major labels, where the rate of use of Content ID from right holders is close to 100%. So having briefly introduced how we view YouTube, spoken about enforcement, now I want to move on to how we've converted this into a business opportunity, a revenue-making opportunity for right holders and for the creative community. So setting aside for a moment YouTube Red, which is a paid subscription version of YouTube, the main way you currently generate revenue on YouTube in Europe is by placing advertising on videos, and the majority of the advertising revenue is paid back to the right holder. Very practically, this is what's called a revenue sharing model, and that does mean that incentives align. So put it in another word, the more successful right holders are on YouTube, the better it is for YouTube as well as for the right holders. Their success is our success. So there are basically two ways you're going to generate revenue on YouTube as a right holder. Through ad revenue. One is on your own channel. So there you think of a movie trailer, the official movie trailer, or think of the official music video. And then the other way is user-generated content or fan uploads, and that's consumers uploading videos that integrate some of your content. And that's where Content ID kicks in, not only as an enforcement tool, but as a tool to actually generate revenue. Content ID, as I said before, will allow you as a right holder to detect when a consumer uploads a video with your content and to place ads, and you will collect the majority of the revenue. Now, I want to emphasize here that this is a new market, a new opportunity. Before Content ID, there was no way for right holders, certainly on YouTube, to generate revenue from this type of activity. Right? So you would benefit indirectly, arguably, from the promotional effect, but you wouldn't generate revenue. Now, thanks to Content ID, this is now a money-making opportunity, and it's become very popular with right holders, as you can tell. Like 95% of videos claimed are monetized on Content ID. So most right holders actually want to generate revenue from consumers uploading their content. How does that translate in terms of scale, if you will? Going back to the music industry example, where you basically have your official music video on the one side, and when you have consumers or fans uploading tributes, lip dubs, cover versions. That second part covered by used by Content ID, will generate half the revenue. So 50% of the revenue that a music label makes on YouTube is generated by user-generated content, fan and consumer uploads. And overall, Content ID, fan uploads, user-generated content have generated $2 billion for right holders on YouTube. And again, this is an entirely new market. So I'm trying to go through a lot of figures because I think they're important to get the right picture of what's going on in this space. So if we go back to the music industry, now if we add up the amount that you make on your own official video channel, and the amounts that you make from user-generated content, you're looking at a total of $3 billion paid to the music industry, and you are looking at $1 billion in 2016 alone. To provide some context, this is what's happening in the music market, or what happened last year according to IFPI figures, I believe. And to put things in perspective, we believe YouTube is a strong net contributor to the growth that we're seeing in the music industry in Europe and worldwide at the moment. Again, for two reasons. One, because we have created and monetized a new market for user-generated content and fan uploads. And second, because we are also very good at increasing the amount of ad revenue in the ad-funded segment that right holders can make in the digital environment. Having gone through how YouTube develops business opportunities for right holders, I want to very briefly talk about some challenges which now are more relevant, I think, to the discussion that this House will be having. And first I want to show a brief slide, I'll come back to that, of how Content ID works as a workflow and how that relates to some of the challenges. Now, I'll mention but a few of the many challenges and the caveats involved in this technology. The first, obviously, is technological. It does require a lot of engineering to match videos on that scale, on that degree of complexity. There is a degree of arms race in the sense that people do, a small number of people do try and circumvent technology like Content ID by changing the pitch of a music video, for example. And so it's a continuous investment of engineering resources, and that partly explains why Content ID is a $60 million investment on the part of YouTube. Second challenge, works identification. So if you go to that slide and you look on the left, content owner, nothing happens if we don't get information from the right holder as to what he owns. So if you look at musical works alone, there are tens of millions of music works out there in the repertoires of collecting societies alone. Each of those can have anything from 2 to 10 different right holders. So this is notoriously complex in terms of managing that information. But without the initial input of a file, but also information from the right holder as to which part of this file you own, which work you own, in which territory, then you can't run any system like Content ID. So that's a second challenge. It's getting that data right. And that is a very, very challenging endeavor. The third challenge, still in relation to this left side of the screen, is I would call it trust or checks and balances. Imagine this stayed like this. Anyone pretty much could use a system like this and claim that they own this particular video. And obviously this will lead to quite unpleasant situations and conflicts. If 3 of us are claiming the same piece of content, then you have a problem. Worse, we might be claiming content that is in the public domain. Such as, NASA footage or other types of public domain material. And if that happens, what you would see is, without checks and balances, is that you would have a tool that would remove public domain content from platforms at scale if you don't have a mechanism to create trust and to try and avoid that type of situation. And fourthly and finally, the last challenge is how to deal with legitimate uses of copyrighted material in Content ID. I'm sorry the font is a bit small, but at the bottom, the ultimate output is Content ID does a match, and Content ID applies the right holder policy. So it detects whether the fan upload or the consumer upload mirrors something that the right holder has provided, and then it does what the right holder has told it to do. There is no way technology can decide whether that particular video is actually lawful, legitimate under, say, a copyright exception. So again, the way we deal with that is we put mechanisms in place to allow consumers to challenge a Content ID claim with the right holder. And to give you an idea of the scale of this phenomenon, for music alone, you're looking at about close to 3,000 challenges a day to Content ID claims on YouTube. So sorry, I was a bit long. These are the challenges, some of the challenges that we see in the use of content filtering or content monitoring technologies. Partly because of these challenges, we do not advocate for mandatory use of these technologies across the board and in legislation. And we do believe far more attention and time should be spent discussing how we can mitigate these types of circumstances and situations. Thank you very much.
Thank you for that presentation, and I now immediately pass the floor to Merit Farron, who is General Counsel at SoundCloud.
Sorry. There we go. Sorry about that. Thank you very much for inviting us to speak at today's event. The issue of the creation of value in digital music and the sharing of value in digital music is of great importance to SoundCloud, and we welcome the opportunity to share our thoughts and ideas. We believe that there are a set of problems today in digital music, and we talk about digital music here specifically, appreciating the fact that these proposals affect many other businesses as well. So our comments are really limited to digital music, to be clear. There are a set of problems today that do affect digital music, and we believe that our current state in copyright in digital music is out of sync with historical copyright norms. We actually believe that those problems, our current problems, can be resolved through thoughtful, energetic changes in copyright law that will benefit our culture and our economy, and that will increase total revenues in digital music to the benefit of all in music. Our focus is on growing the pie and adding efficiencies, and you'll see that, I think, in our comments today. We don't claim to have all the answers by any matter of means, and by the way, we agree with many of the things that have been said by those who preceded me on the panel, but we'll set forth some ideas for discussion today. The things that we suggest be discussed might sound radical to some, but we firmly believe that they are, in fact, in full alignment with the history of copyright law and prescient copyright laws created by those who crafted copyright laws that came ahead of us. We have only to be as thoughtful and balanced in our thinking today as our predecessors were in their day. There are a few things I'm going to talk about today. The first is SoundCloud's unique contributions to digital music and creative expression. The second are comments on the current EU copyright reform proposals. Third, a thought on some copyright fundamentals and monopoly power. And finally, perceived problems and opportunities. First, an introduction to SoundCloud. So some of you may not be familiar with SoundCloud. I can assure you that if we had this room full of teenagers and preteens, you would all know SoundCloud. And you would, many of you, be active users of SoundCloud. We let people discover and enjoy the largest selection of audio from the world's most diverse creator community. This is made possible by an open platform that directly connects creators and fans across the globe. We were founded in Berlin by two Swedes, and we currently reach approximately 175 million monthly listeners from around the world. As such, SoundCloud is a relatively rare success story in internet consumer startups. We were built by artists for artists. SoundCloud, as I say, was founded by two musicians from Sweden. And our focus initially was to create a platform to allow people to share music before music files could really be shared easily on the internet. We moved from that to launching a fee service and an advertiser-supported service. So today, SoundCloud has essentially both user-generated content and a service that looks, for all intents and purposes, like Spotify, but with a lot more uploaded content from users. We are embraced by major labels, mainstream artists, and emerging artists. Our content comes from major labels, and successful artists actively use our platform to build their fan base. It's a very important tool for them all around the world. In addition, we allow, through our uploading, brand new artists who are not established to get started. And many artists have started on SoundCloud, had a big success, gone on to either sign with labels or stayed independent. But we provide a very open platform and are super creative, creator-oriented in a way that enables them. And again, we do provide a crucial support for artistic careers. We now pay, through our pay services, enough money to many smaller creators so that they can make a living in music. And we're continuing to grow our business, but we are paying out real money. Our goal and interest is helping people, helping consumers get great content, but also very, very much helping the creative community make a living and do well so that we will get more fantastic works that are distributed and that enhance our culture. And we are a platform, a very important platform for creative expression. The problems that we have around the globe, not infrequently from censors, are a testament to that fact. One other point that I think is very important for this group to focus on here is that we are particularly embraced by Gen Z, meaning the younger group of consumers on the internet. And they are different from other generations that came before them. They want to be actively engaged. They don't want to just passively consume content. They know what the internet can do in terms of the breadth of content it can make available to them, and they don't want to be prohibited from getting to that content. But at the same time, they are actually very supportive of artists' interests. They see themselves as artists, and they are supportive of artists' interests. They are more, according to our surveys, they are more interested than prior generations in paying for music, more willing to do so, and more willing to turn their backs on piracy if given the right opportunities to do so through legitimate services. If I can figure out how to play this, I will play this audio clip.
I use SoundCloud.
Oh, thank you. This is one of our Gen Z creators. All right, as usual. The live demo doesn't work. All right, well, we'll move on. But this is an individual who got his start on SoundCloud and continues to be extremely enthusiastic about SoundCloud and thankful for the opportunities that we gave to him. A few comments on the proposed directive. We are, as a community of creators, we are broadly supportive of the intent of the current EU copyright reform proposal as it relates to music, in seeking to better protect the rights of creators and to ensure greater transparency and fair remuneration for authors and performers. That said, we can't unfortunately endorse the current proposal. While we laud the efforts that have gone into it, and we do believe it is well-intentioned and intended to serve very legitimate problems that have been called out here today, we fear that its ambiguity and its attempt to regulate technology will actually backfire and will reduce creative expression and will ultimately make it harder for internet businesses to get going in Europe, and will ultimately serve the interests of, and no offense to my friends at YouTube, but to the largest companies who can afford that kind of technology. We ourselves have Content ID. We spend a lot on it. But we know that for a new company to start out and have to figure out those tough questions and to do so in an ambiguous environment would be a very, very tall order. So we think they're problematical for that reason. That said, there are some things that we actually do believe could be done, and we think that the thinking here should be bigger than it is to date. We think we should go further. So what do we propose be discussed? And I, again, emphasize this is for discussion. First, before I go into that, just real quickly, I would lay out a couple thoughts on what has historically made copyright work in music, and music specifically, in the pre-digital era. In crafting copyright laws in the pre-digital era, our predecessors were keenly aware of the need for balance, and the fact that without balance, the monopoly power inherent in a copyright can cause the same kind of negative effects that monopoly causes in other industries. So to deal with this, our predecessors, when created specific statutory licenses and means of getting licenses available to all on transparent bases that allowed radio to get going without requiring individual radio operators to negotiate individual licenses, that allowed the corner record store or a large department store to sell CDs and vinyl without having to go and negotiate hundreds or thousands of licenses. And yet, today, we are on the opposite end of that spectrum. So we and others who want to do legitimate services have an enormous task to figure out who has the rights to close deals with people, even though folks are cooperative. It's an enormous task, it's an enormous expense, and it's a huge barrier to entry that ultimately, again, builds to elimination of variety in offerings for consumers and plays into those who have the most money already to spend on these kinds of activities. So what do we propose? First, what we would propose is that there be a centralized database. The copyright law be reformed to create a centralized music rights database that would allow a one-stop shop where everybody's rights are available and represented and on a European basis. Secondly, we would propose that there be an organized framework for statutory organized licensing so that anyone who wants to create a business as we've launched, which is a subscription internet business or an ad-supported business, just like radio or selling CDs or vinyl, would be able to get a license without having to go and negotiate individual terms. And within this, we would propose that between those two things, there also be mechanisms in place so that artists can see directly what they are making, where their works are being sold and where they're not being sold, and can make good decisions around where they want them made. We would also propose that within the statutory licensing scheme for businesses like ours, like our subscription service, where we're charging people real money every single month, which is what we want to bring money into the music business, that we have a license that permits cover versions and that permits remixes, that permits the kind of things that our customers and Gen Z want and expect, and that enthuses them about music. We also believe that we need to be very careful in doing that to ensure that license fees are properly established. So today we believe that license fees are out of sync with historical norms. That's a problem, obviously, not just for the continued success of businesses like our pay business, but it is also a problem because right now what this space needs, among other things, is lots of marketing to bring more consumers in to subscribe. And if we're not providing enough margin between licensing fees that go out and money charged by the consumer, then we're not going to allow for that crucial piece. So we think that all of these things do need to be done with thought. They need to be established through appropriate rate-setting procedures that are fair, but that take into account the benefits that come from long-term success of these kinds of businesses that actually generate the money that allows for people to be remunerated. Finally, we do think that piracy remains a problem. And the good news from our perspective, from what we see, is that we see a generation of users who are happy to turn their back on piracy if, again, the kind of businesses that we offer can thrive. And we think it's worth making piracy an effort through copyright legislation and through additional looks at A, what can be done, and B, additional marketing activities. We think a coordinated marketing program that is supported by the industry and encourages the notion that it's not cool to not pay the artists is going to be something that resonates very well. So again, we appreciate the opportunity to present our ideas. We realize that a number of things we've proposed have been discussed to some extent and in some cases perhaps not moved on. But we would encourage those who are here to think big, to try and move the needle so that we can, because we firmly believe that there's an opportunity to take European copyright in this space out to a position that will actually put European startups in a better position than other startups are internationally, because they will have an easier time getting going. They will reach a European market immediately and without huge barriers to entry, and that can all be, again, good for everybody in this space. Thank you very much for allowing me to speak.
Thank you, and I'll immediately give the floor to Dr. Christina Angelokopoulos from Cambridge, UK.
Thank you, Ms. Komodini-Katia, and thank you. And hello, everybody. It's a great privilege to be here today. Many thanks to the EPP for the very kind invitation. So before I begin, just by way of a very brief introduction, a very fundamental question: what is the value gap? Of course, I assume that the majority of the people in this room today are intimately familiar already with the notion of the value gap. But just in order to set the scene and set up, in order to contextualize the rest of my presentation, a very brief reminder. The value gap refers to the notion that a misalignment exists between the volume of creative content that is accessed globally, online, using the services of various online platforms, and here primarily we're talking about ad-funded platforms, of course, and the revenue that this access generates for the holders of copyrights and related rights in that content. So, aware of right holders' concerns in this regard, the European Commission recently included a series of different provisions geared at addressing this problem of the value gap in its new proposal for a new directive on copyright in the digital single market that was released in September of last year, in September of 2016. Now, I'm sure that the Commission was very well intentioned in handing down this proposal. Nevertheless, a very close examination of the relevant provisions reveals that a number of problems do exist in this regard, a number of issues do arise, in particular in the form of incompatibilities between the provisions in the current proposal, in the proposal under its current version, and existing EU law. Now, there's a lot that I could say in this regard, but in the interests of brevity, for the purposes of this presentation, I'm only going to concentrate on three main incompatibilities that I've identified between the current version of the proposal and existing European law. So I'll start with incompatibility number one. In order to examine incompatibility number one, we have to start with the relevant recitals of the new proposal, and in particular recital 38 of the proposal. So what this says is that where information society service providers store and provide access to the public to copyright-protected works or other subject matter that is protected by related rights, that is uploaded onto their platforms by their users, thereby, it says, thereby going beyond the mere provision of physical facilities and performing an act of communication to the public, they are obliged to sign a licensing agreement with the right holders unless they are protected by a safe harbour. And this raises an issue because essentially what this wording seems to suggest, and in talks, by the way, I should mention, in talks with Commission officials, it has been indicated to me that this is not the intention, and therefore presumably this is an issue with the wording that can be easily amended. But nevertheless, at the moment, the phrasing of the relevant provision seems to suggest that storing and providing access to the public to protected content uploaded by users amounts to going beyond the mere provision of physical facilities and, in fact, performing an act of communication to the public and thereby infringing copyright. And the reason why this is a problem is that it is not, in fact, obvious that this is, in fact, the case. Examining the current context, the current situation in EU copyright law, certainly Article 3 of the InfoSoc Directive, Article 3 of the Copyright Directive does provide right holders with a right to control the communication of their works to the public. Nevertheless, Article 3 does not give us great detail on how this right of communication to the public is defined. This has been left to the European Court of Justice in Luxembourg. The European Court of Justice has handed down a number of different decisions in this regard. So far, however, no judgment has examined the question of whether hosting of this type, hosting in a way that makes the content publicly available, actually does amount to a communication to the public. So there's a lot of legal uncertainty in this regard, and to make matters worse, if we start examining the way that this right has been interpreted on the national level by the domestic courts of individual member states, what we see is a very fragmented legal landscape. So, for example, there are definitely countries such as France which very easily draw this link. They very easily reach the conclusion that hosting does amount to an act of communication to the public, although it's worth pointing out that France relies very heavily on the safe harbours. And then, on the other hand, there's countries like Germany which reject this idea and have held, for example, that YouTube is not engaging in acts of communication to to the public. Instead, Germany relies on its homegrown, very specialized notion, very individual notion of liability called Störerhaftung. And then, of course, there's countries, perhaps the majority of countries in the EU, such as the UK, which have a number of different case law on communication to the public, but no case law to date that has examined specifically the question of whether hosting amounts to an act of communication to the public. So a lot of legal uncertainty exists in this regard, and it is a bit disconcerting to see this pushed aside, and especially not in the main text of a directive, but in a recital, to have this just taken for granted. So that's incompatibility number 1. I'm going to move on to incompatibility number 2. And in order to do this, we need to move on to the main text of the directive and Article 13 of the directive specifically. What Article 13 says is that the relevant providers, the targeted providers, are under an obligation to take two different measures, two alternative measures, and I'm not going to go into the details of those at the moment, but then it goes on to give an example of what those measures might consist of, and it says that these providers have an obligation to use effective content recognition technologies that are appropriate and proportionate. And this raises issues in view of existing EU law, existing EU directives, and in particular Article 15 of the E-Commerce Directive. Article 15 of the E-Commerce Directive that was introduced in 2000 introduces a prohibition on member states from introducing into their legislation an obligation for intermediaries, a general obligation imposed on intermediaries to monitor the information which they transmit or store. It is quite clear, moreover, that the effective content recognition technologies mentioned by the current version of the proposal amounts to general monitoring. Infringing content can only be effectively recognized by technological tools if the tool monitors all, or at least a significant amount of the content on that platform. It is obviously, logically, simply not possible to recognize unlawful content by only monitoring content that has already been identified as being unlawful. That would be a bit pointless. Moreover, the fact that content recognition technology amounts to general monitoring has also been made clear by the case law of the CJU. Pertinent in this regard is the Netlog case that was handed down in 2012. Netlog concerned a filtering obligation that was going to be imposed on a provider. Filtering involves content recognition technology for the purposes of then filtering out unwanted, unlawful content, removing it from the platform or blocking access to that content. And in Netlog, what the court said is that such technology, the imposition of an obligation to adopt such technology, amounts to an obligation to actively monitor almost all of the data on the platform relating to almost all of the users of that platform, and therefore is something which is not supported by Article 15 of the E-Commerce Directive. It is incompatible with the E-Commerce Directive. So that's it with regard to incompatibility number 2. But the introduction of effective content recognition technologies are also relevant to incompatibility number 3. Because the imposition of an obligation to introduce effective content recognition technologies is not just incompatible with Article 15 of the E-Commerce Directive, it is also incompatible with the notion of a fair balance between competing fundamental rights. And again here I return to the Netlog decision of the CJEU. In Netlog, what the CJEU said was that in deciding which obligations to impose on providers, member states have an obligation to strike a fair balance between the protection of copyright on the one hand, which definitely is something that has to be safeguarded, but on the other hand also the protection of all other relevant fundamental rights of all other affected parties. And in this regard, what the CJEU said was that the relevant filtering mechanism, therefore the effective content recognition mechanism, did not, in fact, achieve such a fair balance. The CJEU reached this conclusion by examining the requirements of 3 different opposing rights to the right of copyright. So it accepted that copyright is protected as a fundamental right under the Charter of Fundamental Rights of the European Union, but it also said that filtering would not strike a fair balance between that right on the one hand and on the other hand the freedom of the intermediary itself to conduct its business, and also the rights of the users of the intermediary, and in particular their right to the protection of their personal data and their freedom of expression. And these 3 are also all rights that are protected under the Charter of Fundamental Rights under Articles 16, 8 and 11 respectively. So ultimately, in conclusion, what I would say, in my personal opinion, the current proposal as it currently stands, at least, is incompatible with current EU law, including both the e-commerce directive and, more worryingly yet, the Charter of Fundamental Rights of the European Union. And as a result, I would recommend that it be significantly amended, if not withdrawn. Now, in this regard, I should mention that I'm currently in the process of writing a study precisely on these incompatibilities. That study will also include recommendations on how to move forward, how to perhaps save the current version of Article 13 of the new proposal, and overcome these incompatibilities, bring it into line with existing European law. This should be published within the next 2 weeks or so. In the meantime, thank you very much for your attention.
Thank you, and I'll give the floor to Olivia, who is the Director of the European Office of EPP.
Thank you very much. I'm just checking. So thank you very much. I will give you the views, the perspective from the recording industry on the issue of the value gap. And I would like to start this presentation by giving you a reminder of how music is available today online across Europe. There are more than 200 licensed digital music services in Europe. The entire national, international, European repertoire is available on those services. You can find consumers can have access to them in different European countries. The catalogue has grown up immensely. And after 15 years of solid decline of the industry and the whole music sector, we can now see, finally a slight, let's say, improvement of the market. We hope that's a beginning. But what we see, I think, most strikingly is that over the years, interest in music has never stopped. And today, with all the different means to consume and access music, the consumption of music is exploding. I mean, people have never listened, accessed, enjoyed music as much as now. The problem we have is that we don't see corresponding revenues in relation to that increase in access and enjoyment of music. Streaming is the biggest driver of the market. To give you an example, for example, in the UK, in 2015, the number of video streams grew by 88%, but the revenue grew only by 0.4%. So that gives you an idea of the difference between consumption and increases revenues. That brings us to the value gap. You have already heard a number of definitions of the value gap. Basically, the problem for the music market in general, the music sector in general, is that because of a lack of clarity, or at least a misuse of certain European rules, a number of services, especially UUC services, user-uploaded content services, have developed based on the fact that people upload the content, but the service promote the content, they suggest other videos, they play an active role, they monetize, they really turn the service into a real music service, but nevertheless claim that they are covered by liability exemptions and therefore do not actually need to negotiate copyright licenses with the rights holders because they're protected by the safe harbors. This leaves the rights holders in a situation where they don't have the possibility to negotiate fair terms for the music. They have the choice between trying to take down, which is actually not efficient and not what they want to do, or accepting a take it or leave it deal. We've heard suggestions that indeed, platforms should have the freedom to try to use the content, etc. Apart from the fact that the comparison with CD stores buy the CDs that they sell, and radios do negotiate licensing agreements with the rights holders. And I think we are faced with a situation where a number of platforms actually set the rules. They define their market. They define what they want to do. They set the rules, and then the rights holders are totally dependent on those platforms. They don't have possibility to decide the monetization, how well it is monetized, how it is monetized. They just have the possibility to ask for something. And even if some of the revenues mentioned seem to be high, actually in relation to what other platforms that do negotiate copyright licenses, there is no real comparison. So this overall devalues music. It also actually has an impact when you want to license official videos to those platforms. If the content is there anyway in another form, even for official videos, you cannot negotiate a real market price. So this has an impact, as I was saying, on music. It creates an unfair advantage over other digital services that are negotiating copyright licenses, and it deprives creators, performers, the whole music chain, and actually the whole creative sectors from fair revenues. To illustrate this value gap, you will see on the right-hand side of this slide the number of users from licensed services, so fully licensed services, subscription services. That amounted in 2015 to 68 million users. It's more or less a double if you add the free tier, providing to the rights holders almost 2 billion in terms of revenues. On the right-hand side, you have the number of users of ad subscription services, so UUC platforms mostly, and then the comparison of the revenues brought to the rights holders. So basically, those UUC or ad-supported services have up between 6 and 12 times as many users, music users, as the other platforms, but they provide less than a quarter of the revenues to the rights holders. Another comparison from service to service, our companies have evaluated on the basis of public available data what one user per year brings to the music sector. For a platform like Spotify, if you blend the paid tier and the free tier, that also includes a free tier, it's in average around 16 euros per user per year. If you we'll take the example of YouTube, which is the biggest platform, in average, it is less than 1 euro per user per year. Now, we've heard figures from YouTube about how much they were paying the rights holders. I need actually to insist that the 3 billion figures is over a number of years, so it's not over 1 year. So it's over a number of years, and that actually currently the subscription services account to 4% of the global music revenues. So it may seem a lot, but it is really a fraction of what the whole music market is, and it is also a fraction of what it should normally be. So this is a problem not only for the music industry, but it's a problem for all rights holders, because as much as music has been on the front line of the digital market, it's very ubiquitous, it's very developed online, it applies to all sorts of creators, and that's why the creators, the producers, the publishers of different sectors have been asking the Commission to provide solutions to this question. So what are those European solutions? Now, the proposed directive introduces 3 elements. A clarification of copyright rules, the fact that copyright applies to UC platforms, a clarification that those platforms do not benefit from the safe harbors when they play an active role, and finally, an obligation to cooperate with the rights holders. So on the first 2 points regarding copyright, I won't go too much into the detail because that's been covered by my colleague from JSAC. But Recital 38 basically clarifies that UUC services do communicate to the public based on a number of, let's say, decisions from the European Court of Justice that make clear that it's not only the uploader, the person who provides the content who communicates to the public, but it's also those who play an indispensable role in the fact that the music is offered and accessible to the public. So that's why you have cases where someone who provides receivers in a hotel is deemed to be making an act of communication to the public because it's enabling people to access that content. This is why also a retransmitter online, who might not be the original broadcaster, is deemed to communicate to the public because it's enabling the public to access the content. The second point is the non-applicability of the hosting safe harbors. And on this, again, we can't say that the proposal of the Commission is innovating in any way, because the proposal is actually based on a number of decisions from the European Court of Justice that have clearly established a difference between the passive and neutral service providers who can be considered as intermediaries and the service providers who might host, who might do a certain number of things, but who are actually playing an active role. And this is an essential distinction that has been highlighted in the cases L'Oréal versus eBay and in the case Google France and Google, which has established a difference between active and service provider. So the notion in Recital 38 is actually not a new notion at all. It is a mere reference to something which is established at European level by the Court of Justice. And actually the recital also uses some examples that have been given by the Court of Justice. These are indications, these are guidance to national member states, to courts and to the stakeholders. So this is to say that those elements in Recital 38 actually do not change copyright law, do not change e-commerce rules, but they provide an essential clarity because until now courts have been at national level and the rights holders and the stakeholders actually have not been entirely clear, and this lack of clarity has really benefited to the platform in question, which have created a business and have left the rights holders dependent on them. The next point relates to the cooperation between UUC services and right owners, and there again the directive introduces an article which requires the platforms to cooperate with the rights holders to implement licensing agreement when there is a licensing agreement, or to prevent availability of unauthorized content, and this is done by way of technology, one of them being identified as content identification technologies. The first thing I think to mention in relation to this is that the priority for the rights holders in the music sector is to license content. The artists want this, the authors want this, the producers want the content to be there. The question is not to eliminate the content, but is to license it on fair terms. And the clarification regarding the liability and the non-application of safe harbors would enable the rights holders to negotiate licenses on fair terms. The existing technology, those kind of technologies do exist, and they are efficient. The problem is not the efficiency. It is not a problem of cost either. If you have technology providers, they will tell you that the cost depends on the size of the platform, on the amount of matches they need to do, but they can provide technology at a very pretty reasonable cost to small platforms, for example. The point, and technology can be very efficient, the point is how is it used by a particular platform? Is it used in an efficient way, or is it used with relatively low standards that let a lot of content go through the net, basically? Another point I would like to make also is that technology or content identification technology, in our view, is totally compatible with the no monitoring obligation in the e-commerce directive. The first point to make is that Article 15 does not apply to the platforms that do not benefit from the safe harbors. So the platforms that are passive and benefit from the safe harbors may claim, Article 15 which applies to them, but Article 15 only applies to platforms that benefit from the safe harbors. So if you're out of that article, you're not concerned by the no monitoring obligation. A second point is that the analysis is actually different from previous speakers in the sense that there is no general monitoring obligation. It concerns specific services. It concerns specific content. The content must be identified by the rights holders, so there is no obligation for platforms to do any active search, to take any decision on whether any content violates or doesn't violate copyright. It's entirely dependent on information provided by the rights holders. There is a balance of interest made with fundamental rights in the sense that first, the technology, the content recognition technology, do not require any dealing with personal data. Regarding the freedom to do business, again, in terms of cost and proportionality, this is assessed in the directive. And again, the cost, from what we understand for the technology providers, are not overly high for the platforms, and they depend, again, as I said, on the size of the platform and the activity of the platform. This does not apply also to platforms that provide not a large amount of content, so it would only apply to the bigger player or to the very active platform that have a large amount of content. And in regarding the relation with freedom of information, freedom of expression, that is always been taken into account in how copyright is drafted by providing for exceptions and by providing for a balance between the right to copyright, protection of copyright, and the protection of expression via exceptions such as quotation, parody, and other forms of exception. And again here, I want to come back to the fact that we see this proposal as actually encouraging the licensing of content by the rights holders, encouraging more content to be there. There are redress mechanisms in case some content is indicated or marked as, as not appearing on the platform. There are redress mechanisms. As far as music is concerned, it is a minority of content, and our experience shows that in cases where there is a counterclaim, there are possibilities for counterclaim for users. These cases are an enormous minority of cases when, if it happens, some content is marked as not having to appear, such as pre-releases, for example. And I would like to say, actually, that the issues raised in relation to content identification are the same issues that already raised in relation to notice and takedown. So it is not a new issue either. So I will conclude this by saying that we see the proposal as necessary to provide clarification and actually increase legal certainty across Europe. It will encourage cooperation between the services and the creative sectors, and fundamentally it will restore fairness in the market, fairness between the creative sectors and the platforms, a level playing field between different online platforms, and that should be for the benefit of the digital single market and also for cultural diversity in Europe. Thank you.
Thank you, and I will immediately give the floor to Maria Martin-Pratt, who doesn't really need any introduction.
Thank you, Ms. Comodini. And as we were just saying, I'm acutely aware of the fact that we are running late, and even worse, that I'm standing in the way of the closing statements of my Director General, and that is a really bad idea from the point of view of any civil servant. I think many arguments have been made, so I can basically touch upon 4 issues that are important to keep in mind when dealing with this value gap discussion. And I could start by what Commissioner Navracic said in his opening statement, which is very important to keep in mind in our future discussions, which is the College, at the time it discussed the proposal that was put on the table by Vice President Ansip and Commissioner Oettinger, had 3 very clear objectives. It wanted to ensure that right holders have a say on how their content is made available, have control on how their content is exploited commercially, and be fairly remunerated. And these are issues that guided the action of the Commission. Now, the value gap, and this has been said, is a complex and large issue because it also means different things for different players. There is the value gap that some have been discussing as regards music and certain online platforms. There is a broader value gap that is discussed by others as regards, in general, for instance, the relation of audiovisual creators, the authors and performers, with, for instance, producers and publishers. These are all important value gaps, and for us are issues we need to address to have credibility in the system of rights that we have put in place in Europe. They are complex issues. That is very clear, because we are going beyond what is our normal approach when harmonizing copyright rules. Normally we have harmonized rights, we have harmonized exceptions, we have ensure good functioning of collective management organizations. But what we are doing now is trying to go beyond, if you want, the definition of our rights and exceptions to make sure that these rights and exceptions are functioning in practice in a meaningful manner. And I take the argument that there are many ways that technology evolves. Some of these ways may not need to be specifically addressed by new legislation. We should not forget that the basic rights in copyright, be them the reproduction right, and these days is the communication to the public right, they have been able to adapt over decades to different modes of exploitation. But we have been confronted to issues that were put to the Commission that seemed to us were producing malfunctioning in the market, in the internal market, the European digital single market. And that's also the important thing to keep in mind. Our objective is to have a well-functioning market for the interest of all the players. Article 13 is not against platforms in the same manner that Articles 14, 15 and 16 is not against publishers or producers. It's just trying to ensure that we have in place the incentives for the different actors to create, to invest, to distribute, because it's also about having a level playing field in the market where people that are providing equivalent services are responding under similar or equivalent rules. I'm not going to get into details. Lots of things have been said, and as in any debate, I agree with some, I agree less with others, and obviously when one has to go in such complex issues in a limited period of time, sometimes there might be a little bit of simplification as regards some arguments. But important from our point of view is to keep in mind as regards Article 13 is the reason why the Commission has put the article on the table is that we see that online distribution of copyright-protected content, it can be music, but it can also audiovisual, it can be pictures, has become far more complex than we used to see before. We were used to see, if you want, a distributor-to-consumer relationship, whether you think about more traditional players, for instance, a broadcaster, or newer players, say Netflix. But we can see as well increasingly now that we have equally important forms of distribution where the content as such is not selected, is not put on the market by the distributor, but by the users. And that's why people talk about user-uploaded content. These are forms of distribution that are important. These are forms of distributions that raise very complex questions from a legal point of view. But the Commission has tried to have a very pragmatic approach in Article 13, which is to say we want to help parties to cooperate and to get to agreements for the exploitation of this content, which again we are not worried about what people do with their own content, is rather what people do with their content that is someone else's creativity or investment. And then as regards Articles 14, 15, 16, which are also a very important part of the proposal of the Commission, and I know as well there will be many questions about why we are doing it, what is the input of the Union at that level. I think it was very well put by Mr. Ager when he said authors and performers function in the internal market. They live in different countries, they exploit the works in different countries. The service providers provide their services in different countries. So we cannot say that the protection of the rights of the authors and performers to have a meaningful remuneration is not an internal market issue. It is an internal market issue for us, and that is also why it's part of the proposal. So that I can say very, very briefly. Obviously, the Commission is now playing the role of trying to help as much as we can the co-legislator, starting by the European Parliament and then the Council, to get to a balanced approach in the package that we have put on the table, which is a complex and a large one, but I'm sure that you will do a very productive work where we will try to help as much as we can. Thank you.
Thanks a lot, and I can confirm that there is continuous discussion between Commission and representatives from the Commission with us asking questions and receiving the information to help us understand also the proposals that the Commission has come up with. We're meant to have a few minutes for questions, but I understand that we are running pretty late already. And I'm also a bit concerned with the time allocated to the translators. And we also still have the concluding remarks of Mr. Viola. So I would take one question if there is. Okay, you've made my role so much easier. So may I please ask Mr. Viola to come up and up here and please give us your concluding remarks. I think the interpreters will be
Madame Comodini, dear honourable members of Parliament and guests, thank you very much for inviting me to say something at the end of this very interesting day. The first thing I want to say is thank you very much. It has been interesting. I've been really following with a lot of interest, passion, and I think we could stay all night long, and continue debating. And I never seen this room so full. So, also the interest is quite remarkable from stakeholders. Yesterday, we presented the so-called data economy package. The legislative part is the e-privacy directive, and this more or less concludes the sets of legislation and regulatory measures we kind of promised with the DSM communication back in May 2 years ago. And out of all these legislative measures we have presented, we knew that the copyright package, which is a large package, let me remember, there are 2 regulations, one on portability, another one about the Marrakesh Treaty. There's a directive, so it's not just the 2 topics we have been discussing, it's a much larger package. We knew that this package, in some parts of it, would have been complex to analyze, a little bit divisive, and we knew that whatever would have been the proposal from the Commission, there would be some applauding and some other being critical or proposing alternatives or saying this is never going to work. So this is part of our responsibility, having in the European institution the duty to present legislation. And now, of course, the ball is over to the 2 co-legislators, and as Maria just said, we are now playing another role, which is the one of the honest broker trying to facilitate a deal. Now, it is important. I think this is one conclusion that we can draw very easily out of the 2 panels. It's a crucial and important topic for the future of our digital economy and for the future of our society. Our proposal, and I'm not idealistic when I say that, is an attempt to approximate fairness. Of course, many of the answers of the things we have been discussing probably are not in legislation, but in the evolution of market and technology, but that takes time. And that's why we felt it was necessary to update certain rules, to propose new rules about what we think is fairness in the Internet ecosphere. Fairness towards the users, that they should continue and enjoy one of the most ingenious invention of the humankind, which is the Internet, with the possibility that you have to reach out everyone and everything. So it remains one of the jewels of our century, and of course we must preserve this, and we cannot afford for a split second to lose this kind of benefits. But there has to be also fairness about the creators, the authors, the journalists, the people that actually work on ideas, materialize ideas, and try, of course, to make a living out of it. And this should be fair in terms of what are the opportunities in the Internet. It should be fair towards SMEs, disruptors, people that have new ideas also. That is very important. And, of course, reward in the right way investments. Of course, this is easy to say, what are the fairness. What is difficult is to translate it into legislation. When I kind of play piano, I know what I want to convey as a feeling. Very rarely I succeed. Now, we claim to have almost succeeded, but of course this is not our role to finish up the job and to really craft the final product, but it's now the role of the co-legislator. And the debate we are having reminds me a little bit of the debate we had a couple of years ago on net neutrality. At that time, of course, we had also quite a divisive and split panorama of people saying this is the end of the Internet, this kind of proposals, others saying, like telco companies, this is the end of investments. None of the two materialized. I think the democratic process in Europe produced something which is a very decent legislation, and probably, given what the new administration, U.S. administration has signaled, that we will be very alone in the world in defending net neutrality in the future. So I think many of you said it. This is a defining moment, and Europe can set really the scene in the world, how to do things. So that's why I think initiatives like this are very important, because, I mean, everyone has ideas. I heard many interesting suggestions, and thinking, if I would have maybe thought these kind of things before, but that no problem. I mean, this legislation is open for ideas, and I'm sure the Parliament, I'm sure the Council will be very receptive. So we are in the middle of a very democratic process, and that's, I think, it really we deserve to a lot of respect for the Parliament that is doing this, and to Council that will do the same parallel exercise. If I give you the feeling of the two panels, I think I could see the way a bit more on the second panel, where I must say there's a convergence of intent. There are differences on the way spelled out, of course, also reflecting the organizations that we're presenting. But I didn't find that one is saying the world is in one way, the world is in the other way. So, in a way, many interesting suggestions, and I think we can see the way forward. But again, it's not now us, it's more Parliament and Council. The first panel, I think, goes at the root of a very serious debate in Europe that has to take place, which is the future of professional journalism. Now, we have been bombarded by the debate on post-truth society, fake news. I don't think that it is in the court of the Parliament or the European institution to propose the European Agency of the Truth. That is not something that I think is the war plan. It's a complex debate, it's a serious debate. One answer which is rather obvious is we must defend the plurality that professional journalism gives. We must defend the way professional journalists are working, because they have as a moral duty, mainly through self-regulation, to actually verify the facts and check the facts. So the only thing we cannot really afford in this debate is that the journalists would suffer out of the evolution of the system. And when I read what happened when one of the most innovative publishing companies of the UK published the accounts very recently, well, there was a surprise, because this company basically has many more online contact, but is losing more money. And as a result, they announced to lay off 70 journalists. So the problem is serious. And we identified one of the solutions to the problem. We think so, but I mean, ready to listen, ready to understand whether there are other solutions. Now, the counter-argument has been, watch out, because by giving this kind of new rights, you might limit the freedom of people in using and exploiting news, which is not the intention at all of the European Commission, to be clear. I mean, so if, I mean, there's something in the text that needs to be clarified, I'm sure that Parliament and Council, which, I mean, the three European institutions have such a track record on civil liberties that there should be no doubt about the fact that this will be a common goal. So I think here the common goal is to preserve a democratic, pluralistic society, and to preserve the role of professional editing, professional journalists, because this is the essence to have, let me say, to survive the post-truth society. So, for how difficult is this debate, and it's difficult, we must find a solution. And my confidence in the democracy that the EU institution really can express in terms of how to do legislation is full. So I'm sure that we will find a solution. Not probably the 100% perfect solution, because this is not of this world, but we will try to approximate, or Parliament and Council will try to approximate. The only thing, again, I think we cannot afford is to say, off of the agenda, this is not an issue. This is an issue. This is a real issue. I do not know of a journalist that is billionaire because of the internet. I know of billionaires because of the internet, but not because they are journalists or because they fight for the truth. So I think fairness is important. And again, we are not inventing the Ministry of Truth to solve the problem of objective representation of the truth, which is, by the way, the sum of many opinions, the sum of many things. And this is not new. It's called democratic society. So thank you very much.
Thank you very much for that. And you are right. I too haven't really seen this room so full. But I've also haven't been to long meetings where we finish almost just 15 minutes late behind time. So I won't make us finish later. I'd just like to say a very big thank you to our guest speakers, a very big thank you to everyone who has attended and who has participated, a very big thank you to the interpreters as well as to all the assistants and advisors from the EPP group who have made this possible. And I am sure that the EPP will not shy away from making bold decisions within this very conflicting scenario. But for sure, as even our guests have indicated today, there is some common ground on which we will develop a position. Thank you. Thank you.